My guest at this time is Matthew Staver. He is the chairman of Liberty Counsel, and he joins me today to respond to a decision from the Arizona Supreme Court which suggests that judges can overrule parents on whether or not their children ought to receive services to encourage them in their transition to a different gender or sex. Matt, thanks very much for being with us.
Good to be with you.
Arizona Republic has the story. This is a decision that came down Thursday from the Arizona Supreme Court. I'm quoting now, Arizona judges can require parents to provide counseling, therapy, and other expert help to children who may be transgender, even if one parent doesn't support treatment, the state's highest court ruled Thursday. But the courts can only intervene when a child would be, quote, at risk for physical danger or significantly impaired emotionally, unquote, without access to those services, a higher standard than the best interest test often used in family court cases. The unanimous ruling partially overturns an April 2018 appeals court decision that highlights the challenges of mediating battles between parents who differ on how to handle kids exploring their gender identities. So, Matt, what do you make of this decision?
Well, I think the Supreme Court of Arizona is wrong, and I think the Arizona Court of Appeals did get it right when last year it ultimately ruled that courts could not take sides between parents over these kinds of issues. These are significant issues, and there are significant consequential health risk to anyone going through this counsel to, quote, change your gender, which is physically and emotionally simply impossible. So the Arizona court just simply gerrymandered this case. There's no law that would allow the courts to interfere between the parents in this kind of a situation. And frankly, I think by injecting a judge, a single judge, that's what you're talking about, a single judge with really no guidelines provided, so that judge has the ability to overrule one of the parents' interest and desires for their children, and also put that child on a path for some physical complications and long-term harm is, I think, reprehensible. And that's exactly what the Arizona Supreme Court has done. It just simply drew this out of the air like you're drawing a rabbit out of the hat, and I think it has serious consequences to families and especially to children.
So you're suggesting it's not grounded in any legal precedent. It's activism, essentially.
No, I think it's just activism to be sure. It's not grounded in any legal precedent at all. In fact, they don't even use the best interest standard because I believe certainly that wouldn't apply here either, but they come up with this other, what they call a higher test. But how do you apply that? The fact of the matter is when a child is going through gender confusion, there is no reason to go down the road, especially at the child's early age, for hormone blocking treatment, hormones of the different gender, and even counseling to go through surgical intervention. And essentially they've opened up the door to do just that, which is going to cause both short and long-term harm to the children, and they should leave those decisions to the parents. Even if the parents cannot agree, what they have done is caused chaos within the family and particularly within the child's life.
Dig into that a little bit more, Matt. You say the decision should be left up to the parents even if they disagree. If they simply can't come to any conclusion, how should this be resolved? Obviously, you don't believe the courts have a role in this, but how should it be dealt with?
Well, here's what you have. You've got a situation where a man decides to leave the home because the man wants to now become a woman and breaks up the marriage. And that person has partial custody of that child, and that person now wants to drag his child right along with him and encourage the boy to do the same thing. And yet the mother also has the best interest of that child in mind, and she doesn't want to see that child harmed. How do you deal with that? The problem is what you do is you do exactly what the Court of Appeals said, and they said that this kind of situation has heightened challenges of mediating battles between parents who differ on how to handle kids exploring their so-called gender identities, frankly, gender confusion. What we do know is that those children who have gender confusion, a vast majority of them grow out of it. So for a parent to push them down into a counseling role and also a medication and potential surgery can be very difficult and harmful for that child, especially when the other parent also has the best interest of that child in mind and doesn't want that child to do so. There are certain things that children should not be allowed to do until they're of age 18, whether or not the parents agree or not. And I think this falls into a very problematic situation where you're going to have a community of people, and even some in the professional community, that will push this child into a very difficult situation that has long-term, lifelong consequences.
Matt, also in this article from the Arizona Republic, it quotes the American Association of Pediatrics, and it says, quote, "The American Association of Pediatrics recommends providing, quote, comprehensive, gender-affirming, and developmentally appropriate health care, unquote, in a safe and inclusive clinical space to children with the diagnosis of gender dysphoria, as well as family-based therapy and support for parents and siblings." But do they mean the gender they are or the gender they feel like they are?
You know, those particular organizations have just become politicized. There's no scientific basis to back up their political statements. In fact, there's just the contrary. Indeed, what they're saying is gender affirming. Affirm the person into what their thinking of confusion is with regards to their sex. Now, in no other area of counseling do you start off with the proposition that you're going to affirm the client. You're going to affirm the client who has that eating disorder. You're going to affirm the client that it's okay to have certain kind of other psychiatric conditions or mental stresses. You don't start off that way saying you're going to affirm anything. You start the process by listening and diagnosing and trying to help. And to begin that proposition by saying gender affirming underscores not the scientific or psychological basis from which they speak, but their political bias.
Lastly, Matt, I know these folks in this case aren't your clients, but if you had a client that got this type of decision from a court, what would be your advice?
Well, I mean, this is difficult. At this point in time, this is the state's highest court, and there's no provision after that unless for some reason the area of law could, in fact, attract the attention of the U.S. Supreme Court, but I doubt it. Certainly there are federal recognized parental rights under the Constitution by virtue of past Supreme Court precedent. But whether the Supreme Court would get involved in a case like this, it's hard to know. I mean, it's a very difficult situation here. Also have to remember, however, that whatever happens in this particular family's life and this child that's at issue, there has to be a showing, at a minimum, even under the Arizona Supreme Court's decision, that by not giving whatever counsel or treatment involved here, whether it's other kinds of counseling or medical treatment, that it has to physically endanger or significantly impair emotionally that child. So if they hold themselves to that standard, it's a higher standard. Fortunately, you know, for this child, maybe decisions will not be made prematurely, but time will tell.
Matt, very interesting. Thank you very much for your time today. We greatly appreciate it.
Thank you.
Matthew Staver is the chairman of Liberty Counsel. I'm Greg Columbus reporting for Radio America.